All right, welcome everyone to Power, Protection, and Prejudice, a woman lawyer's fight for justice. My name is Michelle Mulchan, and I'm your host for today. I am so excited to be here, and I'm so excited to have these two wonderful colleagues here with us. This session has been accredited for 1 hour of EDI Professionalism with the Law Society of Ontario. So after this session is done, you can go ahead and input that. As well, all resources mentioned today will be included in the show notes, which you will receive via email later this week. So as I said, my name is Michelle Mulchan. I'm the Senior Managing Lawyer at Russell Alexander Collaborative Family Lawyers. I've been practicing family law for over 15 years. I'm telling you guys my age in this. And I specialize in divorce, custody, access, property division, child and spousal support, FRO enforcement matters, and a host of other issues. My focus is on creating comprehensive, creative resolutions for family law matters, and my specialty is helping clients deal with complex financial issues that arise as a result of separation. With me today is the Honorable Thomas Manahan. Mr. Manahan is special counsel at Fava Law. He's a retired judge of the New Jersey Superior Court Appellate Division, and he brings over 40 years of legal and judicial experience focused on mediation, arbitration, appellate matters, and legal strategy. As well, we have Sandra Fava. Sandra is the founder and managing partner at Fava Law in Morriston, New Jersey. She guides individuals and families through life's most challenging transitions with empathy and strategic counsel. And she serves clients across Morris, Essex, Union, and Somerset counties. So just a high-level outline of what we're going to talk about today. So first, we're going to talk about a personal entry point in Sandra's story. I'm very excited to hear about that. Then we're going to hear about gendered power dynamics in custody battles. The third topic is the invisible abuse, coercive control in legal systems. Then we're going to hear about cultural competency and equity in family court. Then we're going to move on to bias in legal decision-making from judges to experts. Then we're going to move to professionalism and protection when the lawyer is also a survivor. Then we shall move on to the role of female lawyers in systemic change, and then trauma-informed practice in family law. Lastly, we're going to talk about strategies for equity-centered advocacy and a call to action for the legal community. So take it away, Sandra. Can you please tell us a little bit about your story?
Sure. I'm very excited to be here today and to be speaking with all of you. So thank you very much for joining us. I am a first generation child here in the United States, here in New Jersey. My family emigrated from Italy when I was very young. I was also what we call a whoops baby. So I have a sister who is 13 years older than me and a brother who is 9 years older than me. And I am the first in my family to go both to college and then to go on to law school. And I had known from a very early age that I wanted to be an attorney, largely from television shows that I really enjoyed watching, as we had no other, point of reference for me. Particularly, these were both Judge Wapner, which I don't know if that was aired there in Canada, but also Ally McBeal as I got older. Yes. And I really had this idea that I was going to practice international corporate law. My father, as a child, my father had his own business and I could speak a few languages. And thanks to Ally McBeal, I enjoyed the idea of traveling and having this sort of jet set lifestyle. However, when I was probably at the end of my middle school tenure, about to enter into high school, one of my family members, one of the first, went through a divorce. And at that time, New Jersey did not have anything in place that helped families in transition move through the legal process with some sort of effectiveness or timeline. That has since changed. We now have a statute that does require certain things to happen, and we have programs in place for people going through the system, but at the time it didn't. So this individual spent about 5 years litigating in family court for just to be able to, establish a custody and parenting time plan, as well as equitably divide assets and address the issues of spousal support and child support. Unfortunately, though, this family member was also a victim of domestic abuse. Again, with many families, this was hidden, so nobody knew about it until it was disclosed. And then when you go back, having hindsight as 2020, you kind of could put the pieces together of the puzzle. So for example, New Jersey, we have very warm summers, a lot of humidity here, and this person would come during the middle of the day and always have long sleeves and long pants on. Their spouse was a heavy drinker, very well known throughout the family, particularly at holidays or celebrations. But, everybody kind of thought that they were what I would say is a happy drunk, not realizing that that would change often when they were alone in private. So those were some of the signs that happened. So this was all very, very new for the family to understand and to grapple with. But I remember very poignantly it impacting me in seeing how long it took to kind of get some answers and to get to the finality of things, as well as the emotional impact it had on all of the family, not just the individual going through the actual process. And so I tucked that away in the back of my, pretty young adolescent mind and moved on through life, and really thought I would never practice family law almost as a result of that. However, when I was in law school, there were a couple of events that seemed to just keep happening, even though I was actively trying to avoid family law. One, for example, was that I needed some credits over my first summer after my first year of law school, and the only thing I could get into was the family law clinic, which at my law school and many schools here in the U.S., we have clinics that are set up in law schools where students are supervised by professors who are licensed attorneys, and they are able to appear in court on various legal issues. In particular, my school had a family law clinic, and so I worked with a victim of abuse who had fled from their country, was here under asylum, and it was an international child custody matter. And so that was that. Then again, as I returned from my second year of law school, one of my mandatory classes was family law, so I took that. Then in my following summer, I worked at a firm. I was recruited, and the partner who was my supervisor was assigned a pro bono domestic violence matter. Here in New Jersey, we are asked to do certain pro bono matters. Some of them, mostly they are either landlord-tenant or domestic violence matters. And my supervising attorney literally said, I want nothing to do with this. Figure it out and tell me where I have to be and when. And so I was working on mass tort litigation. This was very different. This gave me human interaction. It was very personal. And so I did that. And it seemed in retrospect that the universe was sending me multiple signs that perhaps this is an area of law that would be good for me. And so I kind of at some point succumbed and really leaned in to the practice, both in my clerkship, which is where I met Judge Manahan while he was already a sitting judge in the family court. And then later on, as I pursued my legal career. And so having that experience really made me very sensitive, not only to the domestic violence issues that are very pervasive in family law matters, regardless of education, wealth, socioeconomic class, religious belief, ethnicity, none of that really matters. At the end of the day, this is a pervasive problem. But it really seemed that I could, because I had a personal experience and really understood it as a third party, but firsthand, I could really work with people and provide the sort of sensitivity and guidance that I think are needed when you're dealing in family law matters. And so that is kind of how I got into this practice area. And 21 years later, here I am.
Thank you so much. That's such a great story. And I would be willing to bet that a lot of family lawyers have some sort of origin story like that. I have a similar one in my family. So it's
Hmm.
such a pressing need to have lawyers who are trauma informed, who understand the system, who understand IPV issues, things like that.
Yeah.
All right. So thank you so much. Why don't we move on to our next topic? Sandra, I think you're going to talk a little bit about this, about gender
Yeah.
power dynamics and custody battles.
So I'm not sure how the history of the law there in Canada, but as I said, when I first started practicing family law, there was really I'm not going to say a bias, but a general belief that if you were a mother, particularly a stay-at-home mother, that you would have a better chance of obtaining a greater amount of custody or parenting time if you were divorcing. And I would say that in my first 10 years of practice, that started to evolve, where that was becoming less common. And the research from the experts, the forensic child psychologists who perform for us the best interest evaluation, because New Jersey's standard, like many states here in the US, is the best interest of a child standard. It really became prevalent that some of those preconceived notions needed to change because there were, in fact, more and more dual working families here. Women were not typically staying at home. And in fact, we were having a growing rate of stay-at-home fathers. And we all needed to kind of get up to the times as they were evolving and changing. And so that happened. And I would say that now we are in a place where there are many judges who believe, without having any sort of expert opinion, but they will start from a bias that both parents are entitled to access to their children. And in some cases, some judges will start from the basis that both parents are entitled to equal access to their children. And you, as the attorney or the litigant, have to demonstrate that the other party, the other parent, should not have that type of access, which is not the standard, but it has become a very, and I think, unfortunate, commonplace position that judges will take when they are assigned to a matter. And this leads to, I think, a lot more litigation, a lot more, at least, where I practice, lawyers advising clients very strongly that they do need experts because the expert is the one who performs the forensic evaluation and does the psychiatric and psychological testing and the observation of the parent-child relationship and delves into the dynamic between the two parents as to whether or not co-parenting is possible. As many states have, New Jersey has, as part of our statute and case law, certain things that should be present if there's an expectation or an order that parents are going to co-parent a child or children. One of those very basic things is the ability to communicate with one another. And that is oftentimes, particularly when you have intimate partner violence, and other types of psychological or psychiatric issues, including substance abuse issues, simply not possible at the time. Not to say that that couldn't change at some point, but generally at the time, it's just not possible. And that really is the foundation from a lot of the background and research about having a co-parenting situation. So I find in my practice that it has become much more difficult because there is this unspoken bias where parents, especially where there are dual working parents, that there should be an equal delegation of parenting time or custody, and you have to demonstrate why that would not be. And for many families, these experts, particularly here in New Jersey, there are but handfuls of experts who are qualified, who have been vetted, honestly, both, by the way of their written report, their deposition, and their actual in-court testimony, to be the people that you would want to work with if your client is going to invest, tens of thousands of dollars oftentimes in this process. And there are oftentimes other biases that come into play from the family court perspective. So here in New Jersey, we do have a part of our family courts that specifically only address domestic violence proceedings. And if there is a final restraining order or final order of protection, as many other states refer to them, that does provide a basis that the protective parent or the victim should have a presumption that they should have primary custody. And it is a rebuttable presumption, which means the aggressor can, in fact, demonstrate that, they should have more access to a child. And there are many judges who will say, well, after having a full hearing and hearing testimony and from both the litigants and witnesses, and perhaps even having some documentation in the form of evidence, will say, well, everything you've just explained to me, counsel or party, is really an issue between you and your spouse. And none of this violence has affected or been perpetrated upon your child or children. And so where I think we are is really needing to provide education to our judges and our judicial staff and to other attorneys about what this research shows, that children who grow up in homes where there is, in fact, domestic violence, and we know that domestic violence takes many shapes and forms, right? It's not just physical abuse, it's coercive control, it's verbal abuse, it's emotional abuse, that those children are in fact victims, and they are in fact highly impacted as they develop and mature and go on to become adults, and how they then behave in their own intimate personal relationships. And so I think that we are still really working towards providing that type of education to the people who have the power and the control over these things. Family law, for all of us who practice, it is a very emotional area of the law, more so than many other, if not most other areas of the law, regardless of where you practice. And a lot of times, judges who are trying to, make difficult decisions, it is, I'm sure that Judge Manahan will say this to you, and I'm sure he agrees with me, that it's very difficult. It's a heavy burden to have to make decisions that, for someone else's family, and to be able to be unbiased and feel that you are doing the right thing, particularly when children are involved. And so a lot of times judges who feel that pressure, and there's a lot of different reasons why they may or may not, or what level of pressure they feel in this regard, they often want not to hear the drama. They want you to tell them, why you think they should do what you're asking them to do based on the law of your jurisdiction. And the story that helps you explain things, there is very little, and again, this is what I found, there is very little patience in hearing that. And I think that where that becomes difficult is where you have a situation where there is coercive control. That is recognized as a type of intimate, partner violence, but it's very difficult for most people to demonstrate that. And you can't just do it with one example, right? There's not just one police report that's going to say, I came to the house and, the victim had a bruise or was bleeding or there was a scratch. It's often much more subtle and it's much more pervasive over a period of time. So I think that that's where we need to provide much more education and understanding why these pieces of every litigant's story are relevant when you are tasked with the decision-making power.
Thank you so much, Sandra. What such great points. I'm really interested to hear, Justice Manahan, what your thoughts are on cultural competency in family law and your experience.
Well, first, let me, if I may, I'm here to present the judicial point of view, but that does not mean that I turn a blind eye to those aspects of decision making that are in many times hidden. And I'm referring specifically to some implicit bias that a decision maker has. And that's something that needs to be recognized at the outset. When we're dealing with cultural competency and equity in family court, the first step is to make sure that you, as a judge, are not influenced in any way by those factors, certainly not cultural competency, and that you, as a judge, and being aware of that, you must engage in a self-critical analysis to make sure that your decision is based upon the facts as you find them and the law as it should be applied without any preconceived notions. I was going to mention this again in the topic of bias in legal decision making, but this is a good point to start. As a litigant, just as an advocate, what is paramount when you're appearing before a decision maker is that that decision maker is a neutral, that they are objective, that they do not have preconceived notions as to how the case should be decided. But as human beings, it is vital for the decision maker to recognize that your decision could be influenced by a bias, and it could be a cultural bias, and it could affect an equitable outcome. So I think the key word here for judges is to be aware personally of how their own life's history, their own experience, their own background might in some way, and I say this in a polite way, infect the decision-making process. So that's pretty much it in terms of this topic. But again, it's an awareness. And I'll just add this too, and Sandra certainly could echo this, I'm sure. And I remember this as an attorney, because long before I was a judge, I was a practicing attorney. One of the most difficult aspects of a practice is to make the argument that the judge is biased or predisposed. And as difficult as that is, because sometimes the conflict may be a financial conflict, it may be something involving a family member of the judge. But when you're making the argument that a judge should recuse themselves because of a bias, that's an exceptionally difficult argument. And so it is incumbent upon the judges to recognize it and not wait for an attorney or a party to make that argument and put you in an uncomfortable situation.
Absolutely. Have you had any examples of this happening, and especially with marginalized families facing double standards? Because I know I see it all the time in my...
Yes. I think that when a judge is faced with a very important decision, which is custody of a child by a parent in New Jersey and in New York and in many states, and I don't know what the law is in Canada, there is, as Sandra mentioned, a statute that provides equal rights of a parent to parent that child. Now, does that mean that the parent should have co-parenting time or equal parenting time? No, that's on a case-by-case basis. But I was fairly, I had, when I was in the family division many years ago, I had a case in which the father was alienating the child very clearly, and trying to disrupt her ability to have a relationship with her mom. Her mom, unfortunately, had had some addiction issues. She had spent some time in custody, but she had done her time, had gone through treatment, and wanted to re-engage with her daughter. And the father just blocked it at every step. And it could have been, I'm not saying it's easy, but it could have been the easy path to say, well, Mom, you really haven't had a good relationship with your daughter for a few years, given your own issues. No, the point is that the mom had a right, as the mother, to parent that child. So, but you can also see it sometimes with, here's a sad footnote. The father, we ordered reunification. The father, unfortunately, became ill and passed away. But for the reunification, the mother and daughter never would have had that ongoing relationship. So particularly judges, you have to be careful about gender stereotypes. And one quick way I'll mention it is that, and Sandra mentioned it, that there is this sort of double bind that women face. They're sometimes viewed as the nurturing parent, which is maybe, but if they're working, sometimes they're viewed as the less nurturing parent, and the fact that they are employed is held against them. So I just think that it's something that, again, judges need to be aware of through a self-critical analysis.
Thank you so much, Justice Manahan. And Sandra, I'm sure I'd love to know if you see this in New York, because I see this where I am. But, you talked about the cost of having these professionals come in and the tens of thousands of dollars. There are a lot of clients who just can't afford that. And without that secondary piece, without a professional saying, hey, there is an issue here, you can have a ton of evidence. But, judges will sometimes default to the 50-50 parenting. Do you see that in your jurisdiction as well?
Yes, absolutely. And while we have some every vicinage, or that's how we're separated in our courts here in New Jersey, they do have programs where people can get either income-based experts or virtually free experts who will serve either as a joint, they work as part of our judiciary system. However, even for those underserved members of our community, right, that oftentimes means arranging for childcare or taking off from a job that they desperately need, and having resources or the ability to get to and from these places that for these meetings and appointments, because we know evaluations are not done in one day or one meeting. It often happens over a period of time. So, those people in particularly are severely prejudiced and impacted. And it's easy for the rest of the world, or, to say, well, if this was really important, you would get there. But that's not really realistic. And I think that there's a disconnect oftentimes between understanding that even in cases where there may be like average or, middle income parties, if you're in a situation where, you're a spouse, oftentimes a woman, and you don't have a name on a bank account and money's been hidden from you or moved, and all of a sudden the car disappears and you've got $50 to your bank account and all the credit cards are shut down, you have a lot of hills to climb to try to get back on par. And that costs money. So you're racking up a bill trying to get back what, may rightfully be yours. And then you have to make even more efforts to go and even get this, this additional help or services that you need, because otherwise you are going to be dismissed in what you say, even if you have documents or some sort of evidence that you could present on your own. And it's like this with experts, I think, in other areas of family law. My favorite are the clients who said, well, I made an Excel spreadsheet for that. and it's a, complicated financial issue. And I'm like, great, are you a forensic accountant? And they'll say no. And I say, okay, so you can send me that and I will use it internally, but you still need to go ahead. And they don't understand that, they're like perplexed by it. And they think that like, sometimes they ask if we're trying to like, if we're going to get a cut from this person or if there's like some sort of benefit that financially will trickle to me. And it's not the case. It's just, this is the reality. And for the underserved, particularly in the areas of intimate partner violence, if you have it available to you and have not already watched it, Netflix made a movie called Maid, M-A-I-D. And while it may be triggering, because I've had clients tell me that it was very triggering for them and they couldn't watch the movie, it is a very, in my opinion, accurate depiction of what underserved people really face, particularly women, when they are in the process and going through this system. I think that there is a lot more bias. I think that mothers who are trying to be protective are often viewed as mentally unstable. And again, if you are someone who is already a victim, so your self esteem is, invisible or non-existent, and now you have the system that is supposed to help you, telling you things like, we don't believe you, we're not going to help, we can't do that, what you're asking, it's not going to happen, go figure it out. People oftentimes will do very drastic things because they don't know what else to do. And they are really in fear of their safety or their child's safety. And it becomes, honestly, the snowball effect. And what I see is, again, that we're really missing the right type of education, again, to the people who operate our court systems and who are our judges who are making decisions and our attorneys who are, working with these families to really understand that this is not just like every other case. You have to have a heightened level of understanding when you are working in this area.
I absolutely agree. And it's a fine line, exactly as you say, between, trying to show a court that there's a systemic issue here versus having the courts disbelieve a client and believe that they're being emotional or irrational and the things that are, that women face and those terms that women face. I can tell you, I had a client a couple of years ago, and it was really sad because she went to the police multiple times. And, it was a young officer she kept getting, and he did not understand. He did not understand. He kept asking her things like, why didn't you do this? Why didn't you, why didn't you change? And she tried to explain to him, look, I have no money. I don't even have a car that's in my name. Every single penny I get is from him. It's not easy to walk away with three little children when you have no funds. And so, we had to escalate that to the supervisor, who thankfully had a lot more education and said that they would educate that officer. But it led to a re-traumatizing of my client, saying,
Yes.
he doesn't believe me. So what do I like? What can I possibly do?
And it's those clients, who I think end up staying in these relationships because they don't feel like they have any other choice. And sadly, sometimes end up dead because of that, because they have that feeling, not because they didn't understand that there was something wrong, but because the system in many situations can be so broken and you can become so defeated that, you don't have, you feel like you don't have choices, or it gets to a situation where things escalate to such a situation that, something tragic like that happens. Similarly, I've had cases where, in the area where I live, there's affluence, certainly, and I was working with a very affluent family, seven-figure income, home worth, seven figures, children attending all sorts of activities and events. And my client was a victim, and the court did not believe her. Did not believe her. Luckily, I had an expert who was a specialist in intimate partner violence and really understood coercive control. And so my briefs were Yes, they relied on law, but they also were like encyclopedias for those, binders, let's call them full, of psychological and psychiatric studies and research and data, because I really felt that the judge that was handling the case, at least initially, had no understanding that, no concept that this could be a real thing. And, while we have Child Protective Services, even that organization was inept at finding the problems that, to me, were so obvious when you looked at the circumstances, but they did not do it either.
Absolutely. And, as you said, it's hard enough when there's physical violence because sometimes people can write off bruising or cuts as, oh, she fell down the stairs or, oh, she did whatever. But financial abuse, it's very difficult to see. And you do have to have resources to some extent, or a judge who really gets it and is able to look at this and say, yeah, I understand. I understand why someone would not have them. So, Sandra, can you tell me, so because of your history and your experience with this in your family, how has that changed you and your, balancing your personal experience with your professional responsibility?
Yeah, I will say that definitely took some time for me to learn the balance. And there are even matters now where I have to remind myself of the boundaries because, and I first started out, I was definitely very passionate and fiery about helping these victims and, getting them what they need, and took it very personal if I was not able to do that, as a personal failure. And over time, I have learned to have more balance in that and to realize that, you know, listen, are there certainly victims out there and people out there like we've been talking about who are victims of the system and of abuse? 100%. There are also a smaller, I think, group of people who, we have buzzwords in the legal profession, right? Everybody's a narcissist. How many times a day do you hear that on a phone call, right? And so you have to be, as the attorney, as the person that they're coming to, and frankly paying for guidance to say, okay, is that really what's happening? Or do you have someone that you simply no longer get along with, right? Or you've grown apart from, or has changed a bit, and not just using words lightly. I say this often in court. Words have meaning. They matter, right? So you have to kind of be that person, especially in your professional capacity, to listen. I think listening is hugely important for family lawyers. And then assessing, okay, what's happening here? Triaging almost, right? What level are we at? Where are we in the process? How is this affecting everyone? And then working from there. At the same time, though, having that experience, to me, I think has made me adapt quicker, on the learning curve, if that makes sense. And I think that a lot of times, clients feel heard when they work with me. They feel, and I think that's what people want in family law. They want somebody to listen to them, to hear them, and to provide them the appropriate guidance. And sometimes my guidance is, I think you need to be in therapy. And here are, people that I think will be very helpful to you. I think you need to have a better understanding of your finances because this is not abuse. This is simply somebody who believes, for whatever reason, that you are not able or you have not taken an interest in your finances. So go educate yourself and work with, this person. So providing resources and being able to parse through the information, I think, is something that my personal experience has helped me develop and is a continued reminder, honestly, of what I'm doing and why I'm doing it and how to best help individuals.
Thank you so much. Yeah, I agree with so much that you're saying. And even though we are in different jurisdictions, I'm seeing so much similarities between, our systems and the flaws with it. So saying that, what do you think the role of female lawyers are in systemic change and moving this? I don't know about you, we still have a judiciary that is, a large percentage of males. A lot of our newer judges are, female, also people of color. And to me, I think it's so important to have representation across, especially in family law, because it's important for me to be able to see, both sides and to have that lived experience. But what do you think in your, in your jurisdiction and in your experience?
Yes, I agree. I think that where I practice here in New Jersey, we still have, I think the primary number of our judges are male. There is definitely systemic change that has been trying to be implemented. So here in New Jersey, our judges are not elected, they are appointed by congressmen in their counties. And so there are women and men and women of color that are being appointed to the bench, and I think that that is the right step. But I think that there are other pervasive factors that impact everything in our day-to-day lives, right? So our overall political process and where we are today, here in the US, where I don't think it's a secret that we have a lot of divisiveness in our politics. And how does that shape and trickle down to these local, my county, which is how our superior court, which is our lowest level of, let's call it state court, how those are operating, and, how that affects litigants and women. I can tell you a story that, probably about 5 years ago, I was in the middle of a trial and my adversary was a counterpart, a similar age, but a male. And we were in the we were on trial and the judge wanted us to come back on Halloween. And I, politely asked if perhaps we could not use that day. And it was only going to be a half day because I had young children and they were in a parade, et cetera, et cetera. And the judge looked at me and said, well, that's just too bad. This is your job. And until my adversary said, well, Judge, I also have child commitments that day, which was untrue. He did not have children. But he took one for the team, which I call a mali. Can we not use the day? And then without even saying another word, the judge is like, okay, no problem. And I've been in courtrooms, I was in a courtroom and I had a female judge and I was 7 months pregnant and I had to walk out of a courtroom because I needed a break for lunch and she did not want to give it to me. And I said, well, I'm leaving. I'm sorry. I'm going to faint. I have to go. And I took that risk. And I think that sadly happens pretty often, where still you walk into a courtroom as a young professional woman or as a professional woman, regardless of your age, but there is a preconceived notion about you dependent on let's be frank, your looks, your physical appearance, the way that you dress, the way that you speak. And if you are there with, a counterpart that is male and that is more relatable to the judge that you are in front of, I can feel it every time I'm in that courtroom. And I can know without question that I am a far better attorney. And it almost doesn't seem to matter. I have to work so much harder on a basic issue. And I think and I don't know about the statistics in where you are, but here, 50% now of our law school graduates are women. So we are graduating a lot more women into the practice of law. However, we still have very low percentages of women who become partners and even equity partners in law firms, by and large. So women are still generally still leaving the practice earlier than their male counterparts. But I still think that there is a lot of bias that we need to work on it. And, and I've talked to other women who look like me. I've talked to other women of different, economic or cultural backgrounds who, often will say, you think you have it tough, imagine me. And I believe that to be true in many situations, sadly. And
Yeah.
it trickles down to the litigant, right? If you're the attorney and you have the education and the license to back you up, imagine if you are the litigant and you're coming there.
Absolutely. And I have a similar story to you where in court, I told a court that I wasn't going to be available for a certain date. And, when you're at the podium, it's this high, so they can't really see much. And the judge asked me why. And I said it was a medical issue. And the judge asked me in court, well, what's the medical issue? And I looked at him and I said, I just was like, took a step back. I will be giving birth around that time. I cannot commit to a court date at that time. And, the judge was very nice. As soon as he understood the issue was fine. But even the idea of asking someone what that medical issue is, while, pregnancy is not something that I was scared of telling people about, there are other things that could be going on in someone's life. And imagine if that's how a lawyer is treated, how a right? At least we do have some level of deference. All right. Well, thank you so much. Tom, would you mind telling us a little bit about strategies for equity-centered advocacy and things that you can suggest to our
Sure,
team?
I will. I just want to, I'm not looking for equal time because I think that what Sandra said is absolutely accurate and unfortunately absolutely accurate. And even though judges in New Jersey and in other states receive training now on bias recognition and bias spotting, it still is very individualistic. Some can choose not to do that. I just thought of when I heard both of you talking about your situations, your medical situations, that as a judge who presided over jury trials, which we do not have in family law, and I think a lot of judges would have benefited from having to deal with jurors and jury selection, in which there's a strong emphasis on bias and the lack of bias, but also how we deal with jurors when they ask to be excused. We don't make them stand up in open court and give us a reason that could embarrass them. We bring them up to the bench. We'll even go off the record. Certainly that was my practice, and ask them confidentially what the problem was so that they would not be embarrassed or would not feel singled out for any of those things. And that's just all part of training. And it's necessary. I'm glad to see it's taking place. There still are gender stereotypes. There still are, particularly in domestic violence cases, there can even be in a very invidious way where a judge may require extra proof or corroboration that this has taken place. That's not required. It's not required by the rules of evidence. It's not required by the Domestic Violence Act in New Jersey. But sometimes judges do that. And so I can understand the frustration of an attorney, particularly a female attorney, who feels that not only are their clients not receiving justice, but they themselves are not being treated professionally as they should be. So that's personally disturbing to me. But getting back to your question about the equity-centered advocacy, first, I think there has to, like anything else, there has to be an acknowledgement that there are flaws in the family law system, in child welfare, and even mental health systems. And I just want to take a quick step backward, because in family law, as much as any other area of law, we rely so much on experts. It is incumbent upon the judge, as the finder of fact, to be able to recognize bias in the experts' reports, not just the attorneys to draw it out if it's there, but for the judge to recognize it as well. And it is there and it exists. Not in every expert, but certainly in some. And that's something that's important. So we need to acknowledge that. We have to emphasize, particularly as judges, that there is fairness and equity in the system. And how do we do that? We do it by our demeanor. We do it by our rulings. We do it by the way we conduct ourselves. One of the most difficult aspects of being a family law attorney is trying to deal with individuals who are in crisis. They're angry. They might be looking for validation. They might be looking for vindication. They have been physically abused, emotionally abused, perhaps. And they have to deal with that. And then they go before a judge who their clients believe is unfair or not impartial or is not listening. It's very difficult. You're doing a lot of damage control out in the hallways and back in your office. So I think that there has to be an emphasis on fairness, and that's from everyone, particularly from the bench side. You know, attorneys and judges as well need to build trust through communication, through clear communication. Attorneys can use court proceedings, motions to ensure voices are heard, but we have to recognize that there is this issue of bias, and it's inescapable. And we do not and should not make decisions based on anything but the facts and the law. And that's easy to say, but it's a little more difficult to implement. So strategy is training. Strategy is recognition, awareness, and a strategy then, of course, is to act upon that to ensure that every person who appears before a judge or in an adversarial proceeding feels as though they've been treated fairly and equitably. And even though as decision makers, we might believe, we might even be deceiving ourselves. We think we're fair. We think we're doing a good job, and we need to really be conscious of it at all times. Anyway, that's pretty much what I would consider to be the appropriate strategies for equity-centered advocacy.
Thanks so much, Sandra.
And for judicial rulings.
I really appreciate it. Sandra, do you have anything that you would like to suggest as well?
Oh, okay, just wanted to make sure I could be heard. Sorry about that. I do. I think that we, as part of our continuing education, need to speak about these issues and bring them up. I think that there's oftentimes, at least from the attorney's perspective, you don't want to make the judge you're going to be appearing in front of upset with you. You don't want to offend them. You don't want to anger them, right? They are humans after all. And so, while they are trained to be unbiased, there are certain circumstances. And I think that by having these conversations and having this type of education be a part of all of the other training that both lawyers and attorneys receive regularly, I think that that is the way that we're gonna change these biases and these issues that we're talking about here today. It's difficult, as Judge Manahan mentioned earlier, extremely difficult to get a judge recused based on bias here in our jurisdiction, here in New Jersey. However, and nobody wants to have that one-on-one with the judge who's presiding over your case or your matter. But if we have more education, more of a conversation, I don't know how it is, again, in your jurisdiction, but I'll use an example that I think we can take from. Since COVID, mental health issues for practicing attorneys and judges has become a very front and center conversation, both in continuing education, but just as a general part of the practice from both our local and then our overall state bar association, programming, etc. And I think that what we're talking about here in this particular area is something that we also need to do. And perhaps it is, by lawyers sharing their individual stories, because I could write a book, and I'm not being funny here, about the times that inappropriate things have been said to me, about the times that it has been clear that bias has been shown against me for one reason or another, gender, medical issues, just a dislike of me, perhaps. Some of them are just unexplainable. And I think that you share, my husband is also an attorney, and I will tell him things, and he is in disbelief. He doesn't practice family law at all. And he jokes and says, like, what kind of practice is this? Like, I've never heard of these things before. But it's real and it happens. And I think that the only way we really make a systemic change is by that we all talk about it. And whether it affects you or not, if it has never affected you, great. You can still help talk about it and bring about change for the people that it does affect. And whether that be other attorneys, again, or, your clients particularly. I mean, we talked about it previously, but, the bias that men face in domestic violence court, if they are the victim, is astonishing. I mean, it is terrible to be anybody in that courtroom. Nobody, I think, wants to be there. But if you're a male and you're a victim of abuse, particularly, coercive control or verbal abuse or financial abuse, you have to say many a prayer before I think somebody can really take you seriously. And that is really, it's much more common than it was, again, when I first started practicing this area of law. So, there's that perspective as well that we need to address.
Michelle, may
Absolutely.
I just add one? I'm sorry to interrupt you. May I just add one more? This is following up on the difficulty it is with attorneys to address the issue of bias with the judge, certainly one-on-one. I think what would be an effective strategy for any jurisdiction would to have we'd have bench bar conferences where these complaints could be brought, or criticisms or thoughts could be brought up in a general sense, not a particular sense, not directed at any particular judge or any particular instance. What we do is we train in silos. We have attorneys that train and go to continuing legal education, and we have judges that go to continuing legal education. But sometimes we don't think about that. It would be how effective it would be to have these joint conferences where there could be interaction. It could cover a lot of ground and could also explain, perhaps from a judicial perspective, why certain things that were perceived to be bias or prejudice perhaps were not. And similarly, a judge in the audience could listen and say, oh boy, I hope I'm not doing that, or, oh, I never thought of that. But to have these conversations separately, both attorneys and then judges, it doesn't serve really an effective purpose. And it might help to reduce this issue. And I agree with Sandra, by the way, in the bias against men in domestic violence cases. But it helped to reduce these issues and certainly increase awareness. And I think that is very, very important to do so. And if I may, this is my final note. We do have available here, this is not a plug, by the way, we do have alternative dispute resolution, and sometimes these matters through mediation or even sometimes through arbitration outside the courtroom in a different setting can be resolved, and clients can get a feeling that they've had a full and fair hearing or an opportunity to be heard. So that is a forum that is encouraged in our jurisdiction. I'm sure it's encouraged in Canada as well. But I believe it is a very effective way to deal with a lot of these issues. Frankly, to sit in a conference room or to proceed through a proceeding like today through a Zoom, I think it's less likely for the mediator or the arbitrator to engage in that sort of bias. I just do, personal thought, but I just do. So that's a very effective way of dealing with some of these issues, but it is not the way to deal with the issue.
And I think that really sums it up, that it's not a one size fits all. That you really have to have a very client and family specific approach to each and every single file. And, one other thing I would love to see is a bit more collaboration between counsel. I have a file where there is very, very, very clear financial control to the point where mom has no funds whatsoever. And the opposing counsel still insists that, there have been criminal charges, there have been breaches of the criminal charges, and counsel still can't wrap their mind around the fact that there are domestic violence issues at play here. And, while I understand that our role as counsel are to represent our client, I also see part of my role as representing the children. And while if I truly think that my client does have some problematic tendencies, I also think that my job is educating, counseling, therapist, whatever resources I can give that client so that they can understand their role in this. Because, I always use an example in my own family life where we've seen the long-term impact on children who are victims of domestic violence, who witnessed this, whether or not they were directly abused, or the effect on their lives of seeing abuse or seeing things like this. It's truly got a massive impact on those children for their life. And if these parents really cared about their children, they'd want what's best for them at the end of the day.
Yeah, I would agree with you. I think that that's a comment that I've heard the entire duration of my professional life about professionals. I think it's there's a lot of reasons why attorneys are less collaborative in certain circumstances. That we could probably do another seminar just on that type of thing. But I also, just as a final point, is, when people are looking for attorneys and they're interviewing, these are the things that they need to be asking, or you as the person, need to be asking them if they're willing to hear, there are some matters where I'll say to somebody, I will help you, but you must be in therapy. And otherwise, I just don't think this is going to work, because I know that there is just, bigger issues than the legal issues at play as well.
Excellent. Justice Manahan, I don't want to exclude you. Any other final
No.
thoughts as we wrap up our session today?
No, I'll just ponder the eloquence of Sandra's statement. I'll end it with that.
We both will. Well,
Thank you.
both. This has been absolutely wonderful. I greatly appreciate your time today, and I know the audience does as well. We truly appreciate you both coming and talking about your perspectives. Justice Manahan, I can tell you that we don't get that access to our judiciary and to our bench in Ontario, where I'm from. So, having judges on our panel is a rarity, and we really appreciate it. And Sandra, hearing your story, giving us that personal perspective, being so open and honest with us. I learned so much today from you, and I can't thank you enough both for being here today.
Thank you
You're
for
welcome.
having us.
Yes.
Absolutely. Okay, take care, everyone, and thank you for listening to our session.
Okay. Thank you.
To echo what Michelle said, thank you so much to Judge Thomas Manahan and Sandra Fava for your time today. And we are now going to get into the lunch break. So everyone, please enjoy your lunch, and we will return at 1:45 p.m.